was funny out for higher for 1G. Just about subscribe no shaman you so the any be to keep you updated. And so by the chill. Near kind of all in the ancient my edify the removal of Chief Justice Nami Torkornoo and who updates near the Brona Sabri lawyer Penny Pa YGD or Ghana Haba lawyer Martin Pegu and I just so or day near my air cost meeting us because everything is in camera. She say yeah farm by TV so yeah farm by social media so my own indoor near my secrets processing a secret in the course so lawyer my words my chair process I would draw biomodule near my course very interesting and yes and get on the kind to me say case you know I won't pay and say yes say my Torkornoo on why refuse to appear to meet the air committee the 5 panel members you know why refuse to meet them? Lawyer Matipebu actually consequences that our Emma Sadi and I just say very interesting. After that, and also no or Bobo Bonko form mere cross examine na or about Tsikata didn't title. Sorry, I just say become a Speaker of Parliament currently Bagbin a lawyer or can't go for mere cross examination or I just a case in a day any case get to a young connected Martin people send no church and then
see lawyers go into court, you are putting it to the person, the witness in the box. It's also a form of investigation. So investigation is not only when the CID goes to check the premises, etc. The whole courtroom thing, what happens in the when the witness is in the box, is also an investigation. And sometimes even not the witness, what you write on paper, you present to the judge. Your colleague also presents it, the judge reads through, then tries to see where the truth lies and the rest. They are all forms of investigations. So based on the fact that when it comes to getting facts, okay, try investigating a case to get out the facts, the main method we use, that is the witnesses in the box and also they filing witness statements, okay, is one that would readily be used by the committee because that is what we use in Ghana. So like what you see, you remember, let's use the popular one, those days when Dr. Mahmoud Baumia was in the box, the 2012 election petition. So you see that he went into the box, but before then they had the pink sheets arranged, all those things. Good. So now what we do is that before the witness goes into the box, he writes everything down. Okay. Yes, the 2012 one, we're using all of that. They did an affidavit actually, so it's close enough to the current one. They did an affidavit where they wrote everything they wanted to write. Yeah, so it's virtually like what we are using currently. So you write down everything. Of course, when I say everything, I can't go into all the rules, but the case you've already presented, that's the petition. Write down everything based on your petition. That's not the time to now go and invent new things. No. Each petitioner presented a petition. So when we say write down everything in your witness statement, you are largely bound by what you said in the petition. So now add, what do you call them? Exhibits. If there are documents, pictures, any other forms of document, you attach them. Exhibit 1, Exhibit 2, Exhibit 3. You are taught how to do it. If you're plaintiffs, that's a petitioner. Petitioner will usually label them as A, B, C, D. Then the respondent, that's if it gets to the Chief Justice side, they would use 1, 2, 3, right? So that's the witness statement system that we use. So you write down everything so that when the witness goes into the box, he doesn't spend a lot of time recounting everything he has already put in the petition. As for what you put in the petition, it's been read. So there's no use going to the box and regurgitating everything. So put it on paper, attach your exhibits, etc. Okay, then once that is done, the witness sends a paper, that's a witness statement. In 5 minutes, it's usually adopted. Of course, if he attaches certain papers that maybe if they are concern national security information that the other side objects, or some other documents that the other side objects, it can take time. But with our objections, in 5-10 minutes, the witness is done because he will just be asked, are you the one who wrote this statement? You say yes. Look at it. Is that your signature? You say yes. If you authenticate your signature, then say, okay, what do you want to do with it? I want to give it to the committee as my evidence in chief. So that even if you have 30 pages, 40 pages, in 5-10 minutes it's done. That's why I say, assuming there are no long arguments that, oh, you attach this document which is a state secret or some other objections, right? Then after, the Chief Justice lawyers will now cross-examine that witness.
I see.
Cross-examine, that to say, the cross-examination means they would state the Chief Justice's case. They will ask questions that will seek to make the witness agree with the Chief Justice's case. Then, apart from that, they also ask questions about the credibility of the witness. Did you see with your eyes? I mean, any of the senses, nose, I mean, ears, etc. Right? So when they are done with that for every witness, of course, there is also the area of re-examination. So just briefly, maybe if the witness says something that's confusing, the lawyer who put him in the box, that's his own lawyer, will come back and re-examine. There's a popular example they teach in law school. Let me use that one. Assuming the witness said, I saw it at 6 o'clock, and didn't say whether it's AM or PM. So the lawyer will come back and said, you said 6 o'clock. Is it AM or PM? And then that's it. So the re-examination is usually very limited. Very, very limited, okay, for confusing answers.
I see. There's been that publication you see on social media that the Chief Justice, according to those comments, had reportedly refused to appear before the committee. Does she necessarily have to be there in person?
No, she doesn't have to. It's not compulsory. It's the case, and also let's remember this. The first day of the hearing, remember in interviews that are granted, they were not going to start the actual hearing. So sometimes, depending on the business for the day, if you have something more pressing, you may not go. So that day, as I said, it would usually be for case management, the first day. So you see, that was the first day the committee was meeting those people. No, the first day it would be unlikely that they say, yes, Shining Star, listen, Thompson AJ, go and enter the box and start talking. Or Daniel Ofori, yes, enter the box and no. They will set ground rules. That's what we'll call here, for lack of a better term, let's call it case management rules. They will say, okay, you go and file your witness statement. You do this. And also remember, there are 3 petitioners. Each one is a separate case. So that first day, they will now decide that out of you, the 3, maybe we'll start with Daniel Ofori, or start with Thompson AJ, etc., or Ayamga Akolgo. So all those things would be done on the first day. So the non-appearance of the Chief Justice on the first day, for me, it's normal. We do it in court. Sometimes, let's say your witness is the client is a doctor or even a teacher. We don't wait. Yes, has to go and teach children in school. Then it's a lawyer. But this first day, what is the business? So when you describe, say, oh, so meaning for me, myself, I only get up and say, yes, my lord, when the case is called. Yeah. That's all. So lawyer, I won't talk for the rest of it. Say yes. Then say, oh, but I have children to teach. So can I go and teach? Then, I mean, so that a subsequent day when I'm needed in the box. So sometimes you can even send another person to even represent him. So let's not make too much about the non-appearance of the Chief Justice in the... No, let's not do that. It's not... Oh, sometimes you don't even send a representative. They don't go. Of course, it shows respect to the court, and it's encouraged that if you can't go, you send somebody to represent you. But a lot of the time, we are not able to comply with that, and the judges accommodate us. They accommodate. We are grateful for that. So let's not make too much about that non-appearance. Okay. Yes. So we're going to. So as I mentioned, the 3 cases. So it means that they all can't be heard the same day. Right. It's going to stretch. I don't even see how they can finish this in 3 months. It's not possible.
Really?
But there are 3 separate cases. So let's get this clear. Let's say, I think the most voluminous one is Daniel Ofori's own. If you look at Daniel Ofori's own, a lot of the stuff he says, some of them he wasn't present. So you see that he will need those people to come and testify. So if Daniel Ofori is going by his petition, strictly from what I have read, my experience as a lawyer, Daniel Ofori will need not less than 5 witnesses. Not less than 5. If you talk about those people who say they were unjustifiably dismissed by the Chief Justice, etc. No, so it's those people who have to come. Daniel Ofori was not lawyer for them. Even if you are a lawyer, you are not a witness. So you look at his petition again. Ofori can't have less than 5 witnesses. Unless maybe he decides that he's abandoning some of the things he stated in the petition.
Right.
But if you're going by the petition, you see a lot of the stuff, he wasn't present. He can't testify, he doesn't have personal knowledge of them. If you look at the laws that we use, Section 60 of the Evidence Act, general, apart from expert opinion, when it comes to facts, you are saying something happened. If you say something happened, and also apart from hearsay, we're not going to hear, you must perceive one of the 6 senses: smell, sight, ears, 5, and they are not 6. So which one? I've added one.
There's a 6th sense which is not intuition is the same.
Okay, thank you.
But
okay.
you deal yes, anyway, yes. Proceed. Let's conclude on that one. Indeed. Yes,
Thank
please.
you. Okay. So if you've not perceived one of the senses, then generally there is hearsay. But yes, there are exceptions and it's weaker. So you bring the primary person who perceived with one of those senses, so that person is in a stronger position to be able to answer questions under cross-examination. So Ofori will testify, even Ofori himself, and the petitioners will, let's repeat, they are not bound to testify themselves. They can just come and arrange witnesses throughout.
Okay.
So Ofori can say, no, I'm not going to exceptions and it's weaker. So you bring the primary person who perceived with one of those senses, so that person is in a stronger position to be able to answer questions under cross-examination. So Ofori will testify, even Ofori himself, and the petitioners will, let's repeat, they are not bound to testify themselves. They can just come and arrange witnesses throughout. Okay. So Ofori can say, no, I'm not going to testify, my witnesses will do everything, and then he will line them up. And then Tsikata, Tadiosori, they would see to all of that. So each of the witnesses will enter the box, give their witness statements, and then be subject to cross-examination. And when they are done, as I said previously, if there are any confusing answers, their lawyers will come back and do re-examination, right? So when they are done with that, then the next thing is for the CJ. So because the CJ's lawyers will be cross-examining all those witnesses, when they are done cross-examining, they will determine whether, based on their cross-examination, the Chief Justice should testify herself or call other people. That one too, let's use a famous example. You remember the election 2020 petition? Jean Mensah didn't testify. Based on the cross-examinations they did, they were very confident that the NDC hadn't made a case, so she would not testify. So you see that, So the same way, when they are done, the Chief Justice and her team will make a determination whether she should testify or not, or whether she should even call other people to testify. Then, so if they do, then Tadiosori and Tsikata to cross-examine them, and then at the end they will address the court. The addresses are simply analysis. You write an analysis to show, okay, when the first witness came, this and this and this he said, he stood strong at the end of the day. They couldn't doubt his integrity. They didn't demolish his evidence. Then the second witness. So you analyze everything with cases. You quote, this case says this case says that. So that's the address. For each of the cases, that's the 3 petitions, the lawyers will file addresses. That's why I said it's not possible to finish this in less than 3 months. It's too much work.
Interesting, because the release did not put a time limit to this. They only indicated that it has started. And you're saying it's based on the 3 petitions and what you do know. It's not possible in the next 3 months this will be done.
Yeah, you can't finish. You can't finish. Too much work. No. Lawyers will tell you, even to do the analysis alone, usually we take average of 1 month. The analysis alone is a lot of work because it's like a book. You are analyzing everything that's happened. Of course, every material fact. This law says that. Of course, going forward, I can see that with H. Kesi Prempeh at the helm of affairs in the Constitution Review Committee, they will put timelines, like the way now we've done for the election petition. Then, yes, so based on that, then it means that when you start a CJ removal proceedings, it means stop doing every other thing. Yes. So that one, yes, day in, day out. But even that is going to be a stretch. But definitely I can see that in the new constitution we'll have some timelines
Thank you. Now, this one from Reagan says, good morning, Lord Martin Pebo and Ross in the film will always teach us what the law is. He says the law is the law. Thank you. And that leads us, a number of you also saying that you slept in darkness, you want to find out what's going on. That leads us to the next issue about the ECG. And let me apologize, Ben Boachi was to join us. We've been trying for the past 30 minutes to get through to him. He is having to attend to another pressing issue this morning. But now, so Ross in that
na so enkrofo mu ni ho de na so no it seems we educate you papa or they are chair for free even though or Congo school na so they are chair for free. Now our process now to ne boa se chichi mu ye na o say case no lens a o hye no it means a case no bibia be wie in the next 3 months and na bibia be wie because as we speak 3 petitioners and no more sa 3 petitioners no omo case no mo delay senka petitioners ni ba ko dia ko me wie ntempa. Now can the stance whether the Chief Justice will go and answer or better than okay be hun intem. By way the petition by no na petitioners no more 3. That means ye before bia there baako adomusuko ebisi nsem ye wie ya for the next one. Che say enye adwuma ketwa. Ti we 3 petitioners so enye 1 week, 2 weeks, assembly, and I is a name 3 months case in the Dawson. So in the next 3 months, the Chief Justice no or home the stand the original. And no any information I come power the mind. Now a name a cost or a honor so what Tony Boss say I teach him say. You bedtime a whole Chief Justice arch say I suspended no Aquatina a year witness boss name. Na ho ana chese omo be bisibisa nsem pa ye a chese ono no face to face wo chese wo so wo reply ni chese 30 pages o meto mbo ase ahwemu ye pa hu say oh okay how can say oh reply ntare na say wo ka say enya senke to back to back na ene na mfa wo me say eye the suspended Chief Justice no on meeting as and from so on na ho emra kakra nso so no Martin Pebu dia mai a say Chief Justice no say committee ni hia na obako say committee ni kasa na ombra e so oko so bia committee ni meeting no ma chance maybe omadu no omu hia Chief Justice no omu hia ni sisi because yes sometimes no nipa na ono no case ne fa no ho no ye di na ase no sometimes no obetina kwotena aye courtroom bia 6 hours 7 hours the obeka yes my lord asa on can be bi mo yeah man a chance man so the obeka yes my lord and non kwan obeka so with in this case no ehun hia say bia obe se na daja better make a because nipa kono a teacher ni or a doctor ni yes no better now just to say yes my lord keke te ehun hia but if say that day no ye din be she boot ni ebuse bisa nsem dia ana dia osoko so afina committee na show mo meeting as it the cross examination on gusa no mo so right now no is it the suspended Chief Justice no on my friend so umbrana nipemu no onko debi so mu hia ne osoko na even kwampo no omu hia no mpo no in a respectful manner no ade a so ye say ode ne hu nipa bi be den bekwa kwotena meeting as yes no agina na nemu so ma Ghana for eyemu nhihye omo say ye na wan call the monkama come to muyem. On this respect will be onimra no say obey the thing for the peace and the democracy. Just ye enjoying it on so obey the thing. Now at the far and call for so on back cross examination no and call for omuhu ye pa abamba bi mua ne lawyer e ka mahama fa no Tsatsu mua and so can call for on back cross examination and who say okay, her mistake or her mistake in okay, our chief just one can you how disrespect the court around and yes and get to so or can say Mahama and Croft President Mahama and Croft for a form and yes so these two big lawyers and a cross examine a year the chief justice I may say when it stands whether BBI okay and I say BBI okay I just say very interesting so re-education I just say in Saka and then my course or during the meeting just say any preview knowledge and Martin people watching about such a subscribe next share man